just want to fast forward to Mr. Curtis Wainwright. What was Mr. Wright's role in this case?
So it is my opinion that Mr. Wright was the only person swinging the hammer, that he was the murderer. And that was based on the some of the crescent-shaped bruises and lacerations on Miss Seaver's skull were all the same size. So he was also the government's star witness, and he got an advantageous plea deal in exchange for his testimony.
And what was your plan for dealing with Mr. Wright, or putting forth your theory of his involvement?
Well, my theory was basically that he was willing to lie in exchange for the best possible outcome. And when you look at his testimony, first time the police talked to him, he said, "I wasn't there." And the next time, "Okay, I was there, but I didn't go in the house." And then it was, "Okay, I was in the house, but I wasn't in the room." And then it was "Okay, I was in the room, but I didn't swing the hammer." And then it was, "Okay, I was in the room and I swung the hammer maybe once or twice, but that was it." And so we had multiple inconsistencies, and there's no way to reconcile those inconsistencies to say that it was mistaken. No, these were lies. These were lies. And even, I believe, in his proffer, Mr. Hunter said, "You are not being truthful." So essentially, one of the jury instructions is, again, you should consider the truthfulness of the witness's statement, specifically looking at, did the witness ever make a prior statement that was inconsistent? And in this case, Mr. Wright absolutely did. And it was very clear that he made these prior inconsistent statements, these lies, in exchange for an advantageous plea deal. And that was not rebutted.
Do you recall if you considered consulting with an expert to advance your theory?
That he lied, that it was recorded. I mean, there was no need for an expert. This was, he gave 5 separate inconsistent statements that one of them could not be true if the other one was. There was no need for an expert. These were lies. Everyone knew they were lies, and yet I cannot see how an expert would say, "Oh yes," when he says he was not in the house, and he said, "Oh, I hit Dr. Seavers with a hammer." There's no way for both of those statements to be true.
Okay. Did you have any desire to speak with Mr. Rogers?
I don't know. So I learned after the trial that Mr. Rogers had changed his story. I had learned after the trial that Ms. Shoemaker had changed her story. And obviously that prior to trial, that would have been helpful, but I hadn't. Yes, my short answer is yes. I would have liked to have spoken to Mr. Rogers. However, he was represented by counsel, and in order to speak to him, I would have to get Ms. Fitzgeorge to agree to allow me to.
Did you make any attempts to do so?
I did not. I did not, because I know that she, her client was facing the death penalty the same way as my client, and Ms. Fitzgeorge is a fierce advocate for her clients.
And then lastly, do you recall how records were shared in this case between your office and?
Okay, so we originally, when this case was going on, well, I'll fast forward. Currently, records are shared from the state to defense. There's kind of a portal, and you download it. If it's a bigger file, then there's a Axon Evidence that you can download these files, and if it's really big, you bring a big flash drive to the state and they give it to you. In this case, we got CDs. It was long enough ago where people were still using CDs. And so I had a big file of CDs. And so at the time, my office was at Winkler and Evans, and we had an entire room at the office that was just dedicated to Mr. Seaver's case. That was all that was in the room. We had trial clothes in there, some paper evidence, but that was the room. And so I don't believe we would have emailed evidence. A lot of this evidence, especially, I remember there were some paper medical records that the court ordered to us to basically not disclose to anyone. Those have since been destroyed.
Let me ask a better, more generalized question. Was all the evidence mainly stored in your office?
Yes.
And then if somebody needed to look at it, would they have had to come to your office?
Yes.
Okay. Do you recall what your email was when you were with Vega Law?
I had a couple. mmummert@fegalaw.com, and then mmummert@mslawpllc.com.
Okay. Do you recall what Jennifer Mummert's email was?
It would have been probably J. Wood, which was her maiden name. I don't know if she ever got a J. Mummert. It's possible.
Okay. I'll pass witness.
State.
Good morning.
Good morning.
You testified that you've been practicing law since 2005, is that right? And you worked at the Public Defender's Office for 8 years?
Yes,
Miss Fitzgeorge was your supervisor.
she was.
You learned a lot from her.
I did.
And 7 of those years at the Public Defender's Office were spent in the felony division, is that correct?
Yes.
And I think during direct you described your trial experience as significant.
Yes.
You had well over 30 felony jury trials by the time you left.
Yes.
And then you went into private practice, right?
I did.
You talked about the Fega law firm and how you came about to represent Mr. Sievers, but your firm was actually representing Mr. Sievers in a number of different actions, is that correct?
Yes, we had his probate, there was the wrongful death, the felony, the dependency. I think that's 5.
And so all of those separate cases, your law firm was involved with representing Mr. Sievers.
That's right.
And that included his murder case.
Yes.
What we're here for today. And you primarily were responsible for handling the criminal case, correct?
That's right.
Is it fair to say that you had a good rapport with Mr. Sievers?
I'd like to think so.
You visited him in jail weekly?
I mean, not every week, but pretty close. Generally, on most Sundays were the days where we would go and we'd see Mr. Sievers in the jail and spend a couple hours with him.
Okay, so these weren't short visits.
No, they were not.
You said they would span for several hours at a time?
Generally, yes.
And away from your visits at the jail, you spent a lot of time working on Mr. Sievers' case.
I can't even begin to calculate how many hours. Between court, research, prep, depositions, yes,
Mr. Severs wanted you to represent him, is that correct?
yes,
And he knew that you were not death qualified?
yes, that was no secret.
Okay, and there was actually a court hearing about that, right?
There was,
He was explained the benefit of having a death qualified attorney,
he was,
but he had retained your firm and had you representing him.
yes,
Despite the knowledge of the protections in place of having a death qualified attorney, he wanted to proceed with you as his counsel of choice.
he did,
And he wanted you to represent him so much that he didn't mind that you were not death qualified.
that's right,
While you were not death qualified, you felt that you had the knowledge, experience, and ability to represent him.
I did,
You would not have represented him had you thought that you would not be able to provide competent representation, is that correct?
that's right,
And you touched on the decision ultimately not to change venue in this case, or move for a change of venue.
yes.
Is that something that you went back and forth on?
It is, it is. I actually went so far as to draft the motion. I believe I started looking for, you need 2 witnesses to testify that they've heard of the case and they're familiar with it. So I know I had a couple affidavits drafted, but ultimately, this is one of those things I just went back and forth on, and ultimately, when I thought about it, it made the most sense to me. I mean, everything that's unknown is a calculated risk, and to me, leaving venue here in Lee County, Florida, I believed benefited Mark the most.
So that was a strategic decision that you made
Yes,
after weighing all of your options.
yes,
And you didn't represent Jimmy Rogers, right?
at no time did I represent Mr. Rogers.
But you are aware that his trial was also local.
Yes,
You talked about attending a CLE seminar, I believe it was
life over death,
Life-
yes,
Life Over
that's it,
Death.
thank you, yes,
and that you learned about jury selection during that seminar.
yes,
Did you follow that paradigm that you learned during the seminar and apply that to Mr. Severs' case?
I did,
And you also had Mr. Masor assisting you during jury selection.
yes, I did,
You two spoke about every potential juror.
every last one.
Did you ever feel like you needed to hire a jury selection expert to assist you?
No,
Had you felt that you needed an expert, would you have sought one out?
if I felt like one was necessary, I would have.
Okay, and Mr. Masor did handle the penalty phase aspect of the case that was in front of the jury, right?
Yes, I did the Spencer hearing, but he did the jury portion,
Okay, so you did the Spencer hearing that was part of the penalty phase in front of the judge.
yes,
So you were still involved in the penalty phase preparations.
I was,
You spoke with a different mitigation specialist.
yes, 2 prior,
Okay, and then you ultimately retained a
Mr.
third one.
Giordano,
You mentioned that you had a room in the office that was dedicated entirely to Mr. Severs' case, is that correct?
that's right,
Did you make that room available to your mitigation specialist?
100% yes,
You gave them access to that room if they needed to
yes,
to get any of the materials?
yes,
And you mentioned that you had Mr. Severs evaluated by Dr. Underwood.
yes.
You were present for those evaluations and meetings?
I do not believe that I was, so I do recall one of the one of the diagnostic tools was the MMPI, which is the Massachusetts Multiphasic Personality Inventory. That has close to 1,000 questions that you write down. And watching Mr. Sievers fill out the MMPI, I think is going to be more helpful to a psychologist than a criminal defense attorney.
Okay. Do you recall attending any of the meetings between Dr. Underwood and Mr. Sievers?
I believe I was there for their initial meeting. You know, I want to just make sure that if I'm introducing someone to Mark, that that there's good chemistry there. That you know, I want to make sure it's a good fit. That they're going to work effectively together.
So is it fair to say you didn't actually observe him, Mr. Sievers, filling out all the questionnaires, but you did take part in some of the process of the evaluation?
Yes.
Okay, and ultimately, Dr. Underwood did not diagnose Mr. Sievers with anything that would have been helpful in his mitigation phase.
No. So for mitigation, things that would have been helpful, schizophrenia, bipolar type 2, you know, things like that nature that, okay, you know, even if the jury were to find someone guilty, okay, well, you know, maybe this is something that due to, you know, a mental illness, they were, you know, this person did not really have as much of the capacity to appreciate what they were doing. But no, there was none of that.
Is that the reason why ultimately Dr. Underwood wasn't called to testify in the case?
Yes, we don't need an expert to say that you know, Mr. Sievers has you know, no mental health issues.
Fair enough. And there was a mention on direct of a expert named J.D. Thomas.
Yes.
But you don't really recall the interaction?
I really don't.
Okay.
I really don't.
You had phrased the theory of the case and explained that there was a lot of extraneous evidence during the trial that you did not feel like related directly to your client, Mr. Sievers.
Yes.
If you had a crime scene expert testify, do you feel that it could have potentially fallen into the aspect of being extraneous rather than helping your client?
I do. Just at a certain point, you hit diminishing returns, and I cannot say in good conscience that, okay, a crime scene expert would have been necessarily very helpful to Mr. Sievers' portion of the case. Our theory has always been that there was no conspiracy, not that there was no murder, not even that Mr. Wright did not commit the murder, just that there was no conspiracy. Our theory of the case is that if it was designed to look like a home invasion robbery and there was $30,000 in cash in the house, why wasn't that taken? If the purpose of this is a murder for hire, why was the murder carried out in the least efficient way possible? And it looked more like anger and rage than somebody who came to take life very efficiently and escape without notice. There were the inconsistencies with the state's theory of the case that this was a murder for hire, and I still believe Mr. Sievers is innocent, and I'll go to my grave believing that. It just didn't make sense. That and the fact that Curtis Wayne Wright was a known liar, and the jury knew it, and yet I think some of the photos of Dr. Sievers were some of the worst photos I've ever seen. And I think at the end of the day, and this is just me speculating here, that the jury was moved to either anger or sympathy over the manner in which Dr. Sievers was murdered.
If I may just have a moment.
Yes, ma'am.
You mentioned the what you referred to as gruesome autopsy photos and crime scene photos. You actually attempted to get those excluded from evidence, right?
Yes.
And you were not successful with that.
I was not. So it was my theory. There was no question that she was dead. There was no question that she was murdered. There was no question about the manner in which she was murdered. The question was Mr. Sievers, was he the mastermind? Did he orchestrate this? And ultimately the gruesome autopsy photos didn't advance the state's theory that yes, he was the one who orchestrated that. If there was some evidence that, hey, Mr. Sievers says, hey, I want you to go and murder my wife with a hammer, and that's how it happened, okay, I can see the relevance there. But it wasn't. And so the sole purpose of the gruesome crime scene photos and autopsy photos was to prejudice the jury against my client.
Rogers never offered to testify in Sievers' case, is that correct?
That's correct. Well, he may have after the fact. I don't know if he has since, but at the time of Mr. Sievers' trial, he had not.
Okay, so when you were preparing for the trial, you never heard from either Mr. Rogers or Miss Fitzgeorge that, hey, Mr. Rogers is willing to testify in an effort to help Mr. Sievers?
No, I would have remembered that, and I would have taken Miss Fitzgeorge up on that.
Okay. One of your themes was that Dr. Sievers was worth more alive than she was dead. Is that correct?
100% yes.
And you tried to discredit the state's murder for hire theory.
Yes.
You tried to show that the murder was not committed for pecuniary gain.
And I was successful in that.
Yes, the jury ultimately did not find that aggravator, correct?
Yes.
When I asked you about the time that you spent on Mark Sievers' case, you said you couldn't even begin to estimate. I mean, if you had to, how many hours do you think you spent on his case?
I mean, given everything, I mean, over 1,000 hours, and it's not even really close. Just looking at the evidence, preparing, going to court, seeing Mr. Sievers in the jail. It was a very, very time-intensive case.
Okay. Did you also have Mr. Al Olson working with you?
I did.
And he was part of your defense team?
We had Mr. Olson as our private investigator, yes.
Okay. And does a Mr. Tom Matthews ring a bell?
Yes, Mr. Matthews was, I believe, an accountant.
Okay. And he would have been someone that you possibly consulted with?
I believe we did, just to kind of look over the Severs finances, and everything indicated that the Severs family was doing well financially. It looked like they were more spenders than savers, but they lived a nice lifestyle. They did the things they wanted to do. They bought the things that they wanted to buy, and as far as I could tell, all of their bills were getting paid, and the Severs family was not in any dire financial trouble.
You mentioned that you felt that Mr. Wright was infatuated, or I'm sorry. No, I'm sorry, did you mention that Mr. Wright was infatuated with Mr. Severs?
I believed he was, yes.
Okay, sorry about that. I couldn't remember at the time. Okay, so why did you believe that he was infatuated with Mr. Severs?
So there were some text messages that just heterosexual friends don't send to each other. You know, like little pet names and things like that. That just, it kind of struck me as this may have been a relationship that, you know, maybe Mr. Wright may have wanted something more out of the relationship.
Severs never admitted to you that he had a relationship with Mr. Wright, though, correct?
He did not, no.
Okay. And are you aware that he actually denied having a relationship during his evaluation with Dr. Underwood?
Yes.
But you were aware that there were potentially some allegations that there was a relationship there?
Just the text messages, just there were some text messages about, hey there, sunshine, is it up, referring to like morning erections. It just, you know, just kind of bizarre.
Did you choose not to focus on that information and have the jury hear that information?
I did.
And why was that?
Well, a couple reasons. One, it was my belief that Mr. Severs wanted to effectuate his constitutional right to remain silent. And for me to really get into that, that would have required Mr. Severs' testimony. Also, I don't know how a jury is going to take that evidence. And if you're not sure, and you're the defense, and you know that the state carries the burden of proof, then you're not going to introduce a new element into the trial that, you know, if there are people on the jury who are homophobic, maybe they hold that against Mark. Maybe they judge Mark based on homophobia and not on the facts and the law.
In addition to possibly having a bias against being homophobic, would it potentially introduce a motive that may not have existed in their minds before?
It absolutely could have. It absolutely could have. And so it just, it ultimately, it didn't make sense to, you know, to just introduce something that I don't know how the jury's going to take it, and I don't know if it could actually make my case worse.
So that was a strategic decision by you not to introduce that evidence and proceed on a theme of that sort?
Yes.
That there was a sexual relationship?
Yes.
All right. During the deposition a few weeks ago, you cried. Is that correct?
Yes. Thank you.
That wasn't the first time that you cried about this case, was it?
No,
You care very much about Mr. Sievers,
I do.
and you care about his case.
I do.
You followed what was going on with his direct appeal.
Yes.
You watched his Florida Supreme Court argument.
No, I actually believe I had court at that time that conflicted with that. But
You didn't travel to Tallahassee to?
no,
Okay,
I did not.
but you did
I followed it.
follow his case. And, you feel that you did everything you can to represent him adequately,
I do. I also feel like I failed.
because you didn't get the result that you were hoping for.
Yes.
If I may just have a moment, Your Honor.
Yes, ma'am.
I'm ready, Your Honor. That's good.
You may
May I-
proceed.
Thank you, Your Honor. There was actually a written stipulation between the defense and the state to not go into the sexual or alleged sexual relationship between Mr. Wright and Mr. Sievers. Is that correct?
I believe so, yes.
Okay. And going back to when the state initially sought to seek the death penalty in this case, you actually moved to get the indictment dismissed. Is that right?
I did.
Okay. I have no further questions, Your Honor.
Defense.
Yes, briefly.